Hi, everyone. Good evening, good afternoon, good morning, wherever you are joining us from. For those of you who are joining us for the first time, welcome to the Essex Public International Law Lecture Series. And for those who have attended our series before, welcome back. I'm Dr. Megan Wong. I'm a lecturer at the School of Law, the University of Essex, and the founding director of the LLM in International Law degree. And together with Dr. Emily Jones, we are the co-founders and co-conveners of the Essex Public International Law Lecture Series. I am so delighted to be your host for today's event with our speaker, Professor Karen Engle, who will be chaired by Dr. Emily Jones. I will defer to Dr. Jones, our chair, to introduce our wonderful speaker today. But as your host, I wanted to speak a little bit more about the Essex Public International Law Lecture Series. Our lecture series opened this spring term with Professor Sean Murphy, who spoke on the conundrum of rising sea levels in international law. And today we're very pleased to have Professor Karen Engle, whose lecture is entitled "The Grip of Sexual Violence and Conflict, Carceral Feminism Meets Human Rights." Now, let me tell you more about the series. The series is built upon two important intellectual traditions of public international law: formalism and international legal practice, international legal theory, including post-colonial and feminist perspectives. The idea for our series stems very much first and foremost from our friendship and is inspired by from our respect for each other's scholarship and research. Dr. Jones and I are both generalist public international lawyers with several specialist interests, including mutual interests in the international law of the sea, international environmental law, and the law on the use of force, but we write from very different approaches. I'm a formalist and Dr. Jones is a critical legal scholar, and we hope that together we bring something for everyone in this series. Let me now introduce our excellent chair for today's event. Dr. Emily Jones is a senior lecturer in law at the University of Essex. She's a generalist public international lawyer specializing in gender and international law, science and technology and international law, and international environmental law. Dr. Jones has recently published a co-authored book with Bloomsbury entitled "The Law of War and Peace, Agenda Analysis, Volume 1, and her monograph, Feminist Theory in International Law, Post-Human Perspectives, is forthcoming with Routledge's Glasshouse series, something to look forward to. And now let me hand the event over. So to speak to my formidable friend, colleague, co-convener, and co-founder, Dr. Emily Jones, to commence the event.
Thank you so much, Dr. Wong. As ever, always a pleasure to be here with you today. And I'm very proud to be chairing this event with Professor Karen Engle, the lecture being entitled "The Grip of Sexual Violence in Conflict, Carceral Feminism Meets Human Rights." And it's nice to see a lot of familiar faces in the audience and also many of our students. So I'm looking forward to the discussion after. So, of course, this talk is in part based on Professor Engle's excellent book, which came out in 2020, which is called "The Grip of Sexual Violence in Conflict." I have it here, which I highly recommend anyone who is interested in sexual violence and conflict and more critical perspectives reads, especially my students. I've told you all you should read it anyway, so hopefully you've started. But to introduce our speaker properly, Professor Karen Engle is Minerva House Drysdale Regents Chair in Law and founder and co-director of the Bernard and Audrey Rapport Center for Human Rights and Justice at the University of Texas School of Law. Professor Engle is the author of numerous articles and is, of course, as I just mentioned, the author of The Grip of Sexual Violence in Conflict. But in addition, she is also the author of The Elusive Promise of Indigenous Development, Rights, Culture and Strategy, which came out in 2010 with Duke University Press, which received the Best Book Award from the American Political Science Association section on human rights. Professor Engle is also the co-editor of several anthologies, most recently an anthology that came out with the University of Pennsylvania Press entitled "Power, Participation and Private Regulatory Initiatives, Human Rights Under Supply Chain Capitalism." Professor Engle has also received residential fellowships from the Institute for Advanced Study in Princeton and the Rockefeller Foundation's Baleago Bellagio Centre, I guess, sorry. I should have practiced that one before. But she served as a Fulbright specialist at Bogota in 2010 and has taught at several universities around the world. Most recently was a visiting professor at Harvard Law School. So as I mentioned, Professor Engle will today be speaking to the title of The Grip of Sexual Violence in Conflict, Carceral Feminism Meets Human Rights. And just a very quick housekeeping note before we begin. If you do want to ask a question, you can see at the bottom of your screen, there's like kind of two little speech bubbles together that says Q&A. So please use that function. You can ask a question at any time, but I'll be asking the questions of Professor Engle at the end of the lecture. And if you do want to remain anonymous, then please click the little tab that says ask my question anonymously. If you don't do that, then I will probably read your name out because it's very hard to kind of not do that. So anyway, without further ado, Professor Engle, over to you whenever you're ready. And thanks so much for being here with us today.
Thanks so much to you, Emily, for the introduction and for being an important interlocutor for much of this work. And thanks to you and Megan for the invitation to be a part of the Essex Public International Law Lecture Series. It's a real honor. So I, of course, wish I were there in person and very much hope that we have the opportunity for extended discussion down the road. I'm going to share my screen here with you, and we'll get started. So the broad questions I'd like to pose for you today are why and how the women's human rights movement became particularly focused on sexual violence and armed conflict, and what have been some of the implications of that focus. Specifically, what happened in both international law and women's rights advocacy over the past 3 decades that made sexual violence in conflict a prominent issue and made international criminal law seem the obviously best site for addressing it. And what feminist approaches to peace and disarmament, development and global equality, and even gender were left on the cutting room floor as women's rights advocates homed in on sexual violence, human rights, and international criminal law. Now, these questions are part of a longer study of mine on how human rights movements, including, as Emily said, those on Indigenous rights and women's rights, how those movements take up law to pursue their aims, and how in the process they end up shaping that law in often unexpected ways. So in the 1980s, women's rights advocates were far from the center of international law of any sort. Yet amazingly, they made significant progress in a relatively short period in rallying the support of international legal institutions and actors. That progress, I contend, stems in no small part from their dominant focus on sexual violence and conflict. It is there that they've arguably achieved the most gains, but in ways that have often moved them away from, if not undermined, some of their initial aims. Now, sexual violence and conflict is both reprehensible and clearly illegal as a matter of international human rights, humanitarian, and criminal law. And no one disputes that. But I'm concerned about the distributive effects of a focus on sexual violence and conflict in terms of issues that don't get addressed, as well as in the ways that the focus has shaped both international law and feminism. So here's how I'll present my argument for you today. First, I want to take a look at what the common sense on sexual violence and conflict is today. And I'll start with that before turning to an overview of some of my critiques of that common sense. And then the bulk of my talk will be focused on the genealogy of the women's human rights movement, and it's zeroing in on sexual violence and conflict. And I'll conclude by looking at what was left on the cutting room floor in this turn to this focus, especially in terms of equality, peace, and development. I'll begin with a 1-minute video released in 2014 by the UK Foreign and Commonwealth Office. It was meant to set the stage for the Global Summit to End Sexual Violence and Conflict, which was co-hosted by then Foreign Secretary William Hague and UN Special Envoy Angelina Jolie. The summit, to which I gather that Foreign Secretary Liz Truss has announced a follow-up, was part of a larger agenda by Hague and Jolie that they brought before the G8 and the UN Security Council as well. The summit was attended by governmental and non-governmental experts in the field. Undoubtedly, some in the room, in this virtual room, were there, many of whom were feminists who had long worked on the issue. As you watch this video, I want you to think about what it says about the harm of sexual violence and conflict, about who the victims and perpetrators of that violence are, and the proper responses to it. And just a heads up that you should really consider both the images and the words because they sometimes diverge. So here we go.
There is a weapon that doesn't just leave physical wounds, it leaves emotional wounds. A weapon of power, violence, and control. A weapon that is just as scary as bombs and bullets, but invisible. Rape. Rape and sexual violence are used against women, girls, men, and boys. Victims are sometimes abandoned by their families. And the anger and shame left behind can tear communities apart and make wars last longer. Especially when the monsters who do it are allowed to get away with it, even live near their victims. But it doesn't have to be this way. Rape and sexual violence are the worst crimes you can imagine, but they are not an inevitable part of war. It's time to act to end sexual violence and conflict. Time to act to bring those responsible to justice. Time to act to let governments know that enough is enough. Time to act so that those who live in fear of sexual violence have a chance to feel safe. Time to act to make your voice heard.
So I take this video seriously because of its basis in transnational feminist and international legal discourse, as well as its embeddedness in much of the international law and policy on sexual violence and conflict. I call it today's common sense, institutional common sense about sexual violence and conflict. So now I want to go through some of the assumptions. So in terms of harm, the video says that rape and sexual violence are the worst crimes you can imagine. They bring physical and emotional wounds and tear communities apart. Even though the video doesn't depict this community as torn apart, it says the words. And this is in fact the common rhetoric we find about sexual violence and conflict. I should note that community also generally connotes ethnic minority, often, but not only in the global South. The victims. Rape and sexual violence are used against women, girls, men, and boys. That's what the video says, though it in fact depicts a woman and a girl as the targets. This is relatively new language, but it is everywhere now in official documentation on sexual violence and conflict. In terms of the perpetrators, the crimes are committed by individual monsters who are depicted as men in general. Criminal punishment is seen as the best way not only to respond to, but to deter sexual violence and conflict. And then finally, in the video, the suggestion is that peace will ensue once those perpetrators are behind the bars. So we just see the family out playing again with apparently little concern about the war that we know continues to rage. Now, I have critiques of each of these elements of the common sense, and I develop them broadly throughout the book. And so I'll just give you a glimpse of the outline of the book, because you can see that I work my way through various international legal sites and advocacy around them, both to demonstrate the pervasiveness of the common sense and the concerns I have about it. In short, Here are the principal critiques, or sort of an overview of my critiques. So the assumption that sexual violence is the worst harm that anyone can experience in war, particularly because of its shame to individual victims, and to communities that are inevitably torn apart by rape, plays out over and over in the response to sexual violence and conflict. The assumption about communities almost always is attached to communities who are Muslim or African or Muslim African. And that view, as I'll say more about, essentializes those communities and even makes them partly responsible because of their perceived shaming of victims in their communities for the harms of rape committed by opposing sides. The narrow victim category that you see in the video, women and girls, is problematic, but so is its expansion that you hear. Solely focused on sexual acts, the latter misses any gendered analysis of the impact of war. Now, the individualization of monsters or bad apples and criminalization go hand in hand. The criminalization response misses structural causes and is often ineffective and used against those who lack power. I also have significant critiques of the doctrine related to the issue of harm. And then seeing those monsters as individual men also misses the extent to which women participate directly and indirectly in conflict, as well as in a variety of harms that ensue. Finally, while you often hear rhetoric about sexual violence making wars last longer, in fact, peace is often forgotten as a goal and is arguably impeded. A common insistence, for example, that there can be no peace agreements that allow for amnesty for sexual violence could mean fewer peace agreements. And perhaps even more importantly, claims of sexual violence are sometimes used to call for armed military, counterterrorism, or other security interventions. Now, hoping that you might share or at least appreciate some of my critiques, I'll spend most of the remainder of this talk setting forth the genealogy of this common sense. At a minimum, I hope to convince you that it isn't simply the result of a logical evolution of women's human rights. Rather, the common sense results from a variety of factors, including the success of a particular feminist approach that has garnered widespread appeal, not only within feminism, but within the mainstream. And that feminism is a strand of structural bias feminism, as I call it, that sees sex as central to male domination and female subordination, and sees sexual domination as constituting the greatest structural impediment to women's emancipation. I contend that the success of this perspective, alongside a broader turn toward criminal law and human rights advocacy on one hand and feminist advocacy on the other, eventually helped to consolidate the components of the international, mostly institutional common sense about sexual violence and conflict. By delving into the contingency of the past, I hope that we can better assess the distributive effects of the choices that were made and begin to imagine different futures. So, allow me to transport you back to the mid to late 1980s, which a few of you might with me remember. Mostly to talk about what was happening in international law and institutions at the time. And then I'll look more closely at some of the feminist debates, even some that predated the women's human rights movement, before looking at what happened to those debates. In the mid to late 1980s, we were nearing the end of the Cold War, though we didn't necessarily know it. The human rights movement was relatively young and largely relied upon naming and shaming of states, mostly by NGOs for enforcement. There were a number of UN human rights treaties, though not nearly as many as there are today, and only a few had individual complaint mechanisms. In 1988, for example, the year before the fall of the Berlin Wall, of the regional human rights courts, only 2 were in operation, and only the European Court of Human Rights had handed down a decision in more than one contentious case. Now, if the human rights legal movement was young, women's human rights were even more nascent. Although women had been organizing transnationally through the UN since the mid-1970s, under the banners of peace, development, and equality, many were just beginning to see mainstream human rights law and movements as an avenue for advancing issues of concern to women. While the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, had been adopted in 1979, you can see that it had half the ratifications it has today. It was a relatively radical but specialized instrument, and even with its existence, women's human rights was not yet a term in play. And I'm going to give you some of these engrams, which are just, I'm not putting them here as empirical evidence, but just to give you a visual approximation of what was happening during the time period. And this is actually looking at the numbers of times in books that have been digitized by Google that certain terms show up. So I put in women's human rights and human rights of women, and you can see where it really starts to take off. This is 1990. As some feminists began to theorize and engage in activism around women's human rights in those years, they saw CEDAW as insufficient for a number of reasons, but especially for its failure to address violence against women, or VAW. And as VAW became the primary focus of their advocacy, women's human rights theorists and activists argued that human rights would need to be radically transformed in order to attend to women who lived much of their lives in the so-called private sphere. Mainstream human rights NGOs at this time strongly opposed that transformation. Now, importantly, international humanitarian law had long recognized rape as a war crime, but it had only been a decade since IHL was formally made applicable to non-international conflicts, and the law was not seen as relevant to most people in the human rights movement. There were no international criminal legal institutions, and in fact, many still remembered the critiques of Nuremberg as victor's justice. So ending impunity or fighting impunity or the culture of impunity was not yet a focus of the human rights movement, although it would soon become one. So when in 1991, the UN announced a post-Cold War World Conference on Human Rights to be held in Vienna in 1993, it's not surprising that it included no mention of women's rights. Yet by the time of the conference, the situation had radically changed. So women's human rights advocates had actually successfully organized to put women's rights on the agenda through a petition. They were undoubtedly assisted at Vienna, though, by the fact that at the time of the conference, it had become clear that the end of the Cold War did not mean peace. Armed conflict was being waged 500 miles away in the former Yugoslavia, and the media was flooded with reports of rapes as part of the conflict. Moreover, the Security Council was now free of the veto deadlock that had prevailed during the Cold War, but it still couldn't agree on whether to intervene militarily. So a month earlier, it had used its Chapter 7 powers under the Charter to establish the International Criminal Tribunal for the former Yugoslavia, or the ICTY. Now, women's rights advocates understandably and impressively took advantage of the moment. And they ended up achieving an outcome document at Vienna that broadly recognized women's rights in both the public and private spheres. It paid significant attention to sexual violence and conflict, and human rights advocates in general began to call upon international and domestic criminal law to respond to it. Thus, international criminal law, mainstream recognition of women's human rights, and a renewed focus on rape and conflict were enmeshed from the beginning. Strikingly, women's human rights advocates achieved these successes with relatively little resistance by either states or mainstream human rights organizations. As strikingly, they did so with little disagreement among feminists themselves, even though internationally engaged feminists had disagreed significantly on a number of issues over the years. Now, I'll discuss the first two areas of disagreement here, although I'll mention the fourth when we get to what was left on the cutting room floor. So on the first, structural bias versus global South, or third world back then feminist critiques. So recall the structural bias feminists, many of whom tended to be from the North, saw male domination and female subordination, particularly in the so-called private sphere, as the defining structure of society to be addressed. Prior to and shortly after Vienna, many third world feminists had argued that structural bias feminists improperly focused on third world cultures as the greatest impediment to their rights. Not only did third world feminists contend that economic disparities between the North and South had an arguably more significant role in women's lives in the South, they also criticized first world feminists for representing third world cultures in essentialized ways as backward and uncivilized, and treating third world women, as one author put it, as, quote, passive objects of male transactions. Some of the more radical third world feminist critiques were explicitly anti-imperialist, building upon earlier anti-imperial work with their male compatriots to call for a new international economic order and to argue for, as the 1975 UN World Conference on Women document put it, quote, the enormous revolutionary potential for economic and social change created by opposition to colonialism, neocolonialism, Zionism, racial discrimination, and apartheid, end quote. Some of that language, including support for the NIEO, actually had made it into CEDAW, which is rarely recognized, but it had largely disappeared by Vienna. Nevertheless, some third world feminists continued to call upon structural bias feminists in the global North to recognize their own complicity in perpetuating the legacy of colonialism, and later the Washington Consensus and neoliberalism. Secondly, sex and the extent to which it is the basis of gender subordination was an ongoing debate that preceded Vienna. Feminist debates about whether sexual violence was an example, paradigmatic, or even the very means of male dominance and female subordination had played out in a number of areas. One was prostitution. Some structural bias feminists at the fore of women's human rights advocacy had been involved with Kathleen Berry in her fight against what she called female sexual slavery, which aimed to connect prostitution to violence, and this is a quote from her, violence in women's lives around the world, in wife battery, rape, incest, bride burning, excision, and pornography. And note the focus on sex-related injury that's on that list. Now, sex-positive feminists in the late 1970s and 80s had strongly opposed this approach to prostitution and its linkage to sex-related violence. Many supported sex workers who themselves had organized transnationally to decriminalize and sometimes to regulate prostitution. Indeed, in 1985, the International Committee for Prostitutes' Rights adopted a world charter that included, among other provisions, that prostitutes would be guaranteed, quote, all human rights and civil liberties, including the freedom of speech, travel, immigration, work, marriage, and motherhood, and the right to unemployment insurance, health insurance, and housing. Further, and most importantly for my purposes, the charter connected with larger efforts to decriminalize sexual conduct, calling for grant of asylum to, quote, anyone denied human rights on the basis of a crime of status, be it prostitution or homosexuality. So they were using rights discourse actually before most feminists were. Now, to be sure, they opposed rape, and they believed its criminal prohibition should be enforced. But they placed it in with a very different list of crimes than those who focused on female sexual slavery. So while the latter ultimately achieved sexual slavery language in the Vienna Convention, you can see that it was surrounded, that rape was surrounded in the list by crimes of sexual violence. And I'll come back to that in a bit, but I want you to see that in the World Charter, something different was going on. The Charter called for the enforcement of criminal laws against fraud, coercion, violence, child sex abuse, child labor, rape, racism everywhere and across national boundaries, whether or not in the context of prostitution. Not only were child sex abuse and rape the only sexual crimes mentioned, the Charter suggested anti-imperial and anti-war feminist stances as it took on racism, violence, and all forms of fraud and coercion. Now, what happened at and around Vienna to quiet these and other debates, making sexual violence in conflict an issue that it seemed that everyone could agree on? The end of the Cold War, a compromise around what I call culturally sensitive universalism, the focus on violence against women, its narrowing to sexual violence in conflict as the principal harm, and the pursuit of criminal law as the primary remedy to it, I suggest, both facilitated agreement or compromise and signaled a victory for structural bias feminism focused on sexual subordination. So let me say something about the fourth and the fifth here. On the fourth, there were two steps to the narrowing of VAW to sexual violence and conflict. So the first step was the focus on armed conflict. Although the Vienna Conference was initially organized around peacetime human rights issues, the unanticipated war in the former Yugoslavia brought international humanitarian law into the conversation. That meant that violence against women could be addressed without necessarily challenging the public-private distinction, and therefore making it palatable or more palatable to mainstream human rights organizations. Now, the second step was the concentration on sexual violence. Women, of course, are harmed in many ways in war times, but in an almost stealth move, sexual harm became the focus. The Vienna Declaration, as you just saw, condemned violations of women's rights in armed conflict as violations of human rights and humanitarian law. It did so, though, with a focus on sexual harms. And in fact, and I think this was part of the goal behind the focus on female sexual slavery, those who pushed this language were expanding the category of rape into a broad category of sexual violence, which was very different from what the sex-positive feminists had put forth. On the fifth element that led to the apparent consensus, Vienna also set in motion criminal law as the principal enforcement mechanism. When the declaration called for, quote, a particularly effective response, the ICT was one of the responses it had in mind. And the ICTY, in fact, turned out to be the beginning of a rapid development of international criminal justice institutions. Some of the most vocal of the structural bias feminists turned to international criminal law as an important site of women's human rights activism. It provided them with a new means of implementation for their approaches to rape and sexual violence. And in fact, later in 1998, they achieved the incorporation of sexual slavery language into the Rome Statute, establishing the International Criminal Court with, as Janet Halley has documented, surprisingly little fanfare. And so I think this is the beginning of that. To be sure, the feminists' turn to international criminal law was itself overdetermined in a number of ways. Human rights advocates were headed in that direction through the ICTY, but also through the successful pursuit of a line of human rights cases, finding that states have an international legal duty to investigate, prosecute, and punish non-state actors who commit serious human rights violations. At the same time, particularly but not only in North America, feminists were increasingly turning to the carceral state to protect women's rights to bodily and sexual integrity. Now, in the context of women's human rights, combined with the other elements I've mentioned, this development in international law participated in the victory, if not a particularly controversial one, for the structural bias feminists focused on sexual subordination. And over time, as you could see in the video, their success led to a common sense understanding that criminal prosecutions of individual bad actors, even monsters, who commit acts of sexual violence will not only end sexual violence and conflict, but will lead to peace. Now, if Vienna neutralized the critiques of third world anti-imperialist and sex-positive feminists and began to offer us a glimpse of the common sense, it was through feminist advocacy to see rape and sexual violence attended to internationally, criminally, and sometimes militarily, which I have a separate section in the book on, that many other aspects of the common sense were forged. In particular, rape had to be the worst crime to get international attention and to be explicitly included and expanded upon in new international criminal statutes. It had to, quote, tear communities apart, to convict individuals for crimes against humanity and genocide, which reinforced in law, politics, and advocacy essentialized understandings of culture and cultures and their reactions to rape. And paradoxically, attributing the greatest harm of rape, shame, to the very ethnic groups who had been targeted. Now, this focus on shame and stigmatization is surprising because it's a far cry from where feminists had hoped to get in their criminalization of rape in the late 20th century. Early on, they said the criminalization should differ from its prohibition in earlier days, where rape was seen as harmful because it constituted an attack on the community's honor. And also, as the sexual nature of the crime became the focus here, gender somewhat ironically dropped out of the picture. Although not even structural bias feminists would agree with all of today's common sense, I don't believe we can say, as many do, that they or feminism more generally was simply co-opted. They elevated or acquiesced in the elevation of the harm of sexual violence as the principal harm to women in general, and especially in war. When they were debating other feminists, sexual violence was gender violence and vice versa. And when they went out into the world, their language of sexual violence resonated with political and institutional actors across political, national, cultural, and religious lines. They are partly responsible for that reception, as well as for the displacement of other issues and approaches along the way, many of which would in fact challenge today's common sense. So let me now turn to the cutting room floor. What was left there? Recall that feminists had organized transnationally from the mid-70s to the mid-80s under the UN's banner of peace, development, and equality. When feminists turned to human rights, they did not carry forward all these issues. And their failure to do so is related to the decreasing traction of the third world and sex-positive critiques, at least among women's human rights advocates. So peace, for instance, has never become a human rights issue. The women's peace movement had actually been on the rise in the mid-1980s. Indeed, Sissy Farenthold, who helped organize the peace tent during the NGO Forum at the 1985 UN World Conference on Women in Nairobi, declared shortly after the event, quote, "What you're seeing now is the birth of a real international women's movement," end quote. But the end of the Cold War took the wind out of the sails of much of that movement. Once it became clear that conflict was here to stay, though, many feminists, rather than continuing to pursue their anti-militaristic demands and the financial demands for redistribution from arms to social provisioning that went along with them, turned instead to the treatment of women in conflict. When in the early 2000s, some women peace advocates promoted what became the Security Council's Women, Peace, and Security agenda, they largely dropped their stronger substantive demands for disarmament and other avenues for ensuring peace, as they worked mostly to bring women more centrally into peace building. And that often missed, of course, that women might be part of the problem. That said, even that narrow inclusive aim has been difficult to pursue as the agenda has become gripped by sexual violence and conflict. Much of the energy around women, gender, and development within the women's human rights movement, along with its critique of colonialism and imperialism, also went by the wayside as eyes turned to violence against women. The shift in focus is not unique to women's human rights, just as the peace one wasn't, as many others have pointed out. But Catherine Sinkink has shown that some of the feminists most focused on women and development went on to be major players in combating violence against women. Unlike violence against women, Sinkink notes, quote, the issue of women and development never spawned a major global network or campaign, in part because the concerns, and this is still her language, were so systemic that they defied individual or group efforts to affect change, end quote. So somehow feminists believed, if naively, that addressing physical harm would be easier. Larger concerns of gender or sexual equality also got narrowed to sexual violence and conflict. Even attention to other types of wartime harm that women experience, from death and the death of loved ones to displacement, loss of infrastructure, livelihood, and multiple forms of human security, have been obscured by the intense focus on sexual harm. And of course, the third world feminist or anti-imperial analyses that argued against essentializing cultures as primitive or shame-based, and noting the economic and political power that comes with that essentialization, has not resurfaced in the ways that one might have imagined. Other approaches to attending to violence and conflict, including sexual violence, have also declined in importance as criminal law has gone from being just one of many tools to becoming the principal and indispensable tool of anti-impunity and transitional justice. The centrality of criminal law persists, often in the name of victims, notwithstanding that as recently as 2015, UN Women released a global study saying that it is, quote, clear that women in conflict-affected settings favor interventions focused less on perpetrators and more on empowering women and girls. UN Women is not alone in this finding. Other studies show that at least some victims are more interested in financial reparations than criminal prosecution, and that many want more than anything a cessation of conflict. So in conclusion, my principal aim with this project is to see that the path that women's human rights took, both in its laser focus on sexual violence and conflict, and in its primary use of criminal law to respond to it, was neither necessary nor natural. Women's human rights advocates have achieved many victories around sexual violence and conflict, but it's time to take stock, revisit priorities, and imagine human rights and global justice anew, partly by putting our differences back on the table. So thank you very much, and I look forward to our exchange.
Wonderful. Thank you so much, Professor Engle, for that fantastic lecture. And just to remind everyone, if you have questions, please use the little Q&A function right at the bottom. I do actually have a question that's come in that I wanted to kind of start us off with. So person thanks you for the lecture, and they say they particularly enjoyed the focus on the historical elements and outlining why we got to the current moment. So they say, my question is, I'm always struck by the recent move that you noted to include men and LGBTI+ people now when thinking about sexual violence in conflict. I was wondering though, to what extent is that inclusion good, and to what extent does it itself risk perpetuating some of the similar issues you raised in relation to the recognition of sexual violence against women in conflict? So maybe we'll start off with that one, because I think that's quite a big one in some ways.
Thank you for that. And I did hint at my response to that and deal with it more in the book, obviously. But I think that right. So on one level, it seems a positive thing to break down the idea that victims are only women, just as it's important to break down the idea that perpetrators are only women. But one of the sort of surprising, perhaps surprising adverse consequences of that is that it ended up reinforcing the sexual part of the harm and violence. And I think power is taken out of the picture in many ways that it actually had opened up the possibility for. So I think it was an important early intervention, and obviously folks who are focused on sexual violence and conflict need to attend to sexual violence against men and by women and all of the various combinations of that. But I still am encouraging us to move away from that exclusive focus on sexual violence, or prominent focus on it.
Thank you so much, Professor Engle. So I have another one that's come in for someone anonymous, but it sounds like they definitely work in this field. So I kind of want to know who it is. But anyway, they say they were thinking of the work of people like Gina Heathcote, myself, and Faye Bird on resistance and compliance. So they say the idea that feminists are caught between using the structure of international law for gains while also needing to seek their aims beyond those structures, because those structures are inherently problematic. They give the example of the WPS agenda and the Security Council. So their question is, to what extent do you think that the focus, for example, on sexual violence versus the lack of focus on peace is caught up in that tension? And what can feminists do to move beyond this? Very big question again. Yeah.
Yeah, one that you could answer. That is a very good question. So in some ways, the question is about whether you use law or want to use law or international law to achieve one's aims. And I guess I would maybe frame it a little bit differently to say we definitely need to engage with international law and not assume that it's just there to fix things. So part of what needs to be done, right, is addressing the many blind spots and biases of international law, and recognizing that adding women to that might reinforce the problematic structures rather than argue against them, or, and I should say, women, queer, better understanding of gender, et cetera. And I guess that's part of why I really want to focus on the extent to which women activists in the 80s and 70s really saw themselves as part of a larger global movement. And the ones that I'm focusing on in particular against imperialism, apartheid, racism, et cetera. And I don't think that's just intersectionality, right? That's about being parts of social movements or critical movements of law that take into account all of the problematic structures that we're trying to argue against. You know, and I think that there's been, and it sounds like the person is well aware of it, a lot of hand-wringing among some of the peace advocates who did participate early on in the Security Council agendas. The Security Council's agenda kind of like, well, why couldn't we have seen that? Of course, it was going to go in this direction. And Diato's written beautifully about that. And, you know, I mean, we don't know exactly how it would have gone. But part of what I'm trying to show is that that wasn't necessary either. I mean, perhaps playing with the Security Council, perhaps Otto's right that there's very little that you can actually do in that setting, but certainly you could be playing against the Security Council in ways that would end up arguably opening up more space. And so that's why I want to be careful when I say that, for example, the women's peace agenda is on the cutting room floor. The peace agenda, anti-militarism, and many of the arguments against it have also gone by the wayside. So feminists were a part of that, and a lot of the shifts that happened globally ended up having an impact on them. But I think it's a good call for solidarity and for thinking more broadly about the stakes.
Fantastic, thank you so much. So I have a slightly different question that's come in here. And I feel like this is possibly from someone in one of my classes, because it's something we've been talking about quite a lot, but I could be wrong. But anyway, so they say, thank you again. They say, so while they agree with critiques of carceral feminism and the criminal turn, just as they broadly agree with prison abolitionism, they're always left wondering what to do next. They say, it seems to me like people who commit sexual violence in conflict maybe should go to prison. So what is your kind of solution in these instances when adopting an anti-carceral feminist approach? It's quite a practical question there, I think. Yeah.
Yeah, it's an important question, and it's interesting because when I wrote the book, I would say I've become, even in the last couple of years, I've been much more focused on prison abolition than when I was working on the book. And I actually think that, but that said, I think what I propose in the book, or what I argue in the book, is pretty much in line with abolitionism, which is more about so first of all, it's not like you just stop throwing people in jail tomorrow. It's about trying to create a world in which prisons are not necessary, but neither are police, nor, depending on how far you go, nor the other carceral apparatus. So I think, a lot of my call is, this is hard, because if you're focused on sexual violence and conflict, then there is a question of what do you do when you have perpetrators. And I'm not saying that there shouldn't be criminal law around it. I'm more interested in saying, though, that if we really want to end sexual violence and conflict, we need to end conflict. And we shouldn't pretend that criminal law has any deterrent effect whatsoever, because we pretty much know that there's no evidence for that.
Yeah, no, I think that's a really, really helpful answer. So thank you for that one. So another question that's come in that I'm trying to kind of select based on a variety of different perspectives here. So this one is asking a bit more about American feminism. So they say, to what extent do you feel that American feminism has shaped some of the problems here? So you touched a bit on this, but in particular, I was thinking about the debate between what you called structural bias feminism and sex positive feminism in the US, and how that debate seems to shape feminism so much there and not in other places in some ways. And how that then seems to have been transposed to the international. So in other words, is this partly an issue of white American women directing the agenda?
So first of all, I should say that a lot of the debates around prostitution took place more broadly in Europe. So that doesn't mean that it's still not global North white, but I gave you some snippets of the American debate, but they weren't all within the United States. And I think a lot of the really important and interesting work around sex work is taking place in places, I would say in India is where some of the most, I find provocative and good work being done. So that's just to say that I think that there continue to be resonances of these debates, right? That they're just not happening in the women's human rights movement is part of what I was trying to say. That said, in the American feminists ended up playing important roles, as did a lot of other feminists, and this is where it gets complicated, or women's rights advocates from a variety of places. So especially in the early UN World Conferences on Women, there were all these debates, which is part of what I was trying to pull out, that really were between American feminists and sometimes other feminists in the global North and many feminists in the global South. That's not absolute. That's not the only way the lines were drawn. And Jocelyn Alcott's has done really interesting work on showing how that divide, that the issues play out in different ways at different times, even as early as the 1975 Mexico City conference, where the Mexican feminists were quite divided. But those seem to be more like global debates than what eventually ensued. Somewhat, okay, so I didn't talk about this in the talk, but there's a chapter that's pretty much guided by a big debate between two American feminists, Catherine McKinnon and Rhonda Copeland, over how rape and sexual violence in conflict should be treated during wartime. And in fact, that was the third debate that I had that I didn't talk about. And what's interesting about that is that they had their own debate, and then they had different alliances, including different alliances with people in the former Yugoslavia. So that was, very much when they were talking about the ICTY. In fact, a lot of people accused them of intervening, and others accused them of, or others very much lauded them for their advocacy. So I'm kind of circling around because I really want to resist that this was just an American debate, which isn't to say that certain Americans didn't play really important roles and continue to play important roles in it. And I worry that doing that also does a disservice to, a lot of women from the third world signed on to a petition to get women's rights on the 1993 Vienna Convention. I don't think that they had exactly the same aims as those maybe who eventually propelled forward a lot of the work there.
Fantastic. Yeah, I think that really helps to answer that one. So thank you so much. I'm kind of aware of the time, but I really want to ask this one. So if you don't mind, we'll use this as the last question. So it comes in from Sherry Levensky. It says, thank you so much for your tremendous talk and for your scholarship, especially your Hemingway book review. So Sherry asks, I was wondering if you could speak on female perpetrators for a moment. This question might not make much sense, but in the book, you talk about the shame from sexual violence. And from my reading, you don't necessarily connect the idea of shame and the lack of attention to female perpetrators. But I was wondering if you could expand on your thoughts on the idea that female perpetrators are pushed from focus due to the shame from feminists that a woman did that.
Can you just say that last bit?
Yeah, so asking about the connection, wondering what your thoughts are on the idea that female perpetrators are pushed from focus due to the shame from feminists that a woman did that kind of idea.
Yeah. So just to be clear, I don't argue that it's because of the shaming of feminists that they're pushed from view. If that's the question, but
I think she's more saying like that's something that has happened and wondering on your thoughts on that. I think that's kind of the idea.
Right. Yeah, I mean, I think that there's certainly, and other people have done more work on this than I, but there's certainly the attempt to exceptionalize those women, right? So sometimes it's shame, and that's not just coming from feminists themselves, and we saw that in the ICTR, but sometimes it's also just, yeah, okay, we can acknowledge that sometimes there are women who are bad actors, but they weren't being women, right? And this is where, as much as I'm trying to push forth the line of women's peace activists in a lot of ways, I think there was a problematic cultural feminism underlying a lot of the strategies to say that, if we just get women in the room, we'll all agree. And so that's somewhat in tension with my push in the book and elsewhere to say that, women are a part of the problem, and women are nationalists, and women participate, even if not in combat or direct atrocities, or not, right? That's less my focus, actually. I think what we really don't see is the many, many ways in which politically women participate in conflict.
Yeah, definitely. Thank you very much. Yeah, I think that kind of focus on essentialism of women's roles as well is really interesting there, right? So yeah, anyway, we are out of time, I'm afraid. We had like loads of questions coming asking about female perpetrators there as well, so that's quite funny.
Oh, will you please send them to me? I would love to see them.
Yeah, I would. I'll make sure to kind of send them all to you. So Zoom collects them all, so that's really good. So we can do that. But we should probably let you get on with your day, and it's quite late for people here in the UK, so let people rest for their evening. But I just wanted to say thank you so much for that fantastic lecture. I think it was really interesting, and yeah, great to see so much engagement with it as well. So thank you so much for joining us.
Well, thank you. And I look forward to engaging with your new work as well.
Yeah, it sounds good. We'll have to continue the conversation. All right. Thank you very much. Have a good day, good evening all. Bye.